बोला.
The accused Narayan Kamble, age 65, is charged under Indian Penal Code, Section 306, abetment of suicide in the death of Vasudev Pawar, age 25, who was a worker under contract with the Bruhan Mumbai Municipal Corporation. The deceased person committed suicide on the night of 24th August 2012 by choking himself to death inside a sewer located at Ram Vilas Road, Andheri East. The police, after its thorough investigation, concluded in its report that it was a clear case of suicide. No manual worker with an experience of doing the job for 5 years like the deceased would go inside the sewers without any kind of protection to eyes, nose or skin. These workers are fully aware of the various hazardous gases that breathe inside the sewers and know that they can lead to instant death if proper precaution is not taken. When the dead body of the deceased was recovered from the sewer, no safety equipment was found near him even after searching for many hours. No wounds, injuries or signs of struggle were found on Vasudev Pawar's body, nor did the postmortem show any other cause for death other than the poisonous gases which were inhaled. According to Section 306, if any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. There is sufficient evidence collected through police investigation as presented to your honor that the suicide of Vasudev Pawar was provoked by performance of accused party Narayan Kamble and his troop that took place at Sitla Devi Nagar on 21st August is the locality in which the deceased resided and was seen in attendance of the performance in question. It should be noted that the suicide took place just 2 days after the performance. As the statement of an eyewitness who is willing to testify in this honorable court, there was one song performed by the accused which coaxed and encouraged manhole workers to commit suicide by deeply inhaling the toxic gases found inside the sewers. It is no coincidence that the song in question suggests exactly the method of suicide, that is, deliberate negligence of safety norms and regulations by which the deceased took his life. According to this song, giving up your life is the one and only rational solution for certain sections of the society to gain dignity and respect. Here, Narayan Kamble is openly endorsing and encouraging an act which is an offence under Section 309. I would also like to bring to the attention of the Honorable Court that the accused has been previously charged under Dramatic Performances Act and has been sufficiently warned to not perform any material that is seditious in nature or harmful to the general society. In spite of these warnings, the accused performed the dramatic piece in question without the approval of concerned censor authorities and with the deliberate intent of causing harm, inciting seditious sentiments and corrupting people present at the performance. If the accused is granted bail for this non-bailable and non-compoundable offence, there is a risk that he will once again commit the same offence as his track record shows complete disregard and disrespect for the court's orders. माझं झालं.
According to the report filed by the investigating officer, the death of Vasudev Pawar is assumed to be an act of suicide. I would like to request the court to review this conclusion critically in the light of evidence that is highly inconclusive and subjective. As per Halesbury's Laws of England, 4th edition, 9th volume, page 686, a finding of suicide must be on evidence of intention. Every act of self-destruction is, in common language, described by the word suicide, provided it is an intentional act of a party knowing the probable consequence of what he is about. Suicide is never to be presumed. Intention is the essential legal ingredient. To attract the ingredients of abetment, the intention of the accused to aid or instigate or abet the deceased to commit suicide is necessary. In this case, let alone intention, there is absolutely no logical reason or motivation as to why the accused would abet the alleged suicide. As for the Dramatic Performances Act, which my colleague cited as grounds for rejecting bail, Your Honor, it's a Victorian law dating back to 1876. And it's up to our judgment about its relevance in a post-colonial country.
No, but this is not a valid argument. It is the law, it is there.
Secondly, whether it was a dramatic performance at all is also debatable, because it was not a fictional or a dramatized depiction of events, in which case Whether it required a censor certificate is a gray area.
पण त्यांना यापूर्वी सुद्धा या ऍक्ट खाली चार्ज केलंय आणि हा ड्रामॅटिक परफॉर्मन्स आहे की नाही हे ऑनरेबल कोर्टाने आधीच डिसाईड केलेलं आहे.
तुमचं बरोबर आहे. त्याआधी प्रूव्ह झालेलं आहे. दॅट इज नॉट अ व्हॅलिड पॉईंट.
Your Honor, there is not a single witness in the charge sheet who claims to have seen such a song being performed. There is also no documentary evidence whatsoever to support the claims of the police, and the burden is on the prosecution to prove its case. I will sincerely request the court to discharge my client at this stage itself and save him from further agony of undergoing the trial. In the alternative, I would request Your Honor to grant him bail.
Your Honor, there is prima facie sufficient evidence to frame the charge against the accused, and I strongly oppose the request for bail.
Okay. Leah, heard. Fit case to frame charges. Bail plea is to be rejected. Next hearing on 11th November.